The Minnesota Department of Public Safety by jkharing, Administrative Law, Module 14. The Minnesota Department of Public Safety is headed by a commissioner, the current one being Mona Doman. The Department of Public Safety functions as an enforcement, licensing, and services agency that provides law enforcement, traffic safety, alcohol and gambling, fire safety, driver's licensing, vehicle registration, emergency management, and public safety services. DPS operates under Minnesota Statute Chapter 299A. The Office of the Commissioner works with local, state, and federal legislators, law enforcement agencies, emergency responders, and public and private organizations in public safety. The intelligible principle for the Department of Public Safety is found within its three functions of enforcement, licensing, and service. The functions of enforcement of the Department of Public Safety include gambling, who is eligible to gamble, what gambling devices can be used, how are gambling prizes managed, ensuring compliance with state tribal agreements, licensure of gambling devices, and investigating gambling crime. Here are some statistics on gambling taken from DPS's website. There are 204 criminal investigations in the last year, 87 tribal state compact compliance inspections, which resulted in tribal state compact compliance inspections of 456 slot machines inspected, 68 blackjack tables inspected, 19 tribal audits, 21,586 slot management audits, 5 technology support assistants employed, and 23 corporate background and licensing investigations. Minnesota Department of Public Safety has over 100 departments of motor vehicle locations. They also have commercial driver's license exams, Class D driver's license exams, instructor permit exams, license renewal applications, tab renewals, and motorcycle license exams. DPS provides a service of law enforcement. There are 87 counties in Minnesota with a total of 431 law enforcement agencies throughout the state. Here are some agency statistics, agency breakdown by number of officers, taken from www.dps.gov. The number of officers, agencies, and percentage is reflected on this table. 13 agencies employ 1 officer. 97 agencies employ 2 to 7 officers. 213 agencies employ between 8 and 25 officers. 65 agencies employ 26 to 50 officers. 26 agencies employ 51 through 100 officers, and 17 agencies employ over 100 officers. The Minnesota Department of Public Safety has a rulemaking document that can be found on its website. One rule promulgated by DPS is crime victim reparations. It began in 1974, and the latest version was approved by the Office of Administrative Hearings in December 2013. The Department of Public Safety operates the Crime Victims Reparations Board. The board consists of 5 members, including 1 victim and 1 doctor. True to its name, the purpose of the board is to compensate victims of crime and victims' families. Applications for compensation are available on the DPS website. To qualify for compensation, people can be the victims of robbery, domestic abuse, kidnapping, child abuse, homicide, drunk driving, or assault. In order to receive compensation, the crime must have taken place in Minnesota. The victim may not be guilty of a crime themselves. The crime must have been reported to police within 30 days of occurrence, and the victim has 3 years to file. Compensation is used to cover funeral and burial expenses, counseling and mental health services, medical and dental bills, child care and in-home personal care assistance, crime scene cleanup, and cover the expenses of survivors of victims. Compensation is only offered for expenses not covered by another source, such as a charity or medical insurance. If someone is unhappy with the decision of the Crime Victims Reparations Board, they can appeal with an administrative law judge. The judge will recommend action to the board, who makes another decision. The Office of Hearings employs 16 administrative law judges, all of whom are attorneys. The Department of Public Safety exercises discretion over revoking driver's licenses. The most common reason for revocation is driving under the influence of alcohol. When someone is arrested for a DUI, they face criminal charges and lose their driver's license. DPS gives the arresting officer authority to charge drunk drivers with a crime if blood alcohol content is at 0.08% or higher. This is called the implied consent law, section 169A.50 to section 169A.53. If the driver has a valid license, revocation begins 7 days from the arrest. Chapter 171 allows the Commissioner of Public Safety to revoke, suspend, cancel, or refuse a driver's license. The process begins when the Commissioner's office notifies the driver by letter. The driver can ask the court to review the Commissioner's decision and a petition for hearing on reinstatement of driver's license. The burden of proof rests on the driver and their attorney. Chapter 171 does not apply to revoked licenses under Minnesota Statute 169A.52, such as those that were revoked for failing an alcohol test. Under Chapter 171, the petitioner has 180 days to file with the court. The petitioner is required to file a petition for hearing on reinstatement of driver's license, an affidavit of service upon the Commissioner of Public Safety, and a certificate of representation in parties. There are also fees and county law library fees that must be paid. After filing a case, the court informs the petitioner and Commission of Public Safety by hearing notice with a court date and judge's name. The petitioner has the burden of proof and may bring evidence or witnesses. The petitioner is allowed procedural due process by having a chance to recover their license through judicial review. De novo hearings are allowed. The Department of Public Safety's rulemaking is guided by the Minnesota Administrative Procedure Act. The purpose of the Administrative Procedure Act is to oversee agency powers, ensure procedural due process, and allow public access to government information. Under Minnesota Statute 14.055, a petitioner can ask an agency for variance on a rule created by that agency. the petitioner has the burden of proof to show that the rule will not serve its purpose if applied to the petitioner's case, the rule causes hardship, or the rule is in violation of public interest. Variance can also not affect legal or economic rights of people or entities. The petitioned agency is required to submit a public statement to an administrative law judge regarding the variance. All law enforcement agencies are required to have a policy on handling complaints against a police officer. A claimant contacts the officer's direct employer, and a staff member will walk claimant through the process of filing a complaint. The claimant fills out a detailed form and is kept up to date of the status. For more information on police complaints, click on the link below to read a Pioneer Press article called Police Complaints Up Significantly in 2018, but Officials Are at a Loss for Why. The chart below was taken from the City of St. Paul's website regarding avenues for review of possible police misconduct. The internal process. A complaint is filed, Internal Affairs investigates, and sends to the PCI ARC, who reviews cases and makes a recommendation to the police chief. The police chief may decide to take disciplinary action, which the officer accused can appeal. If disciplinary action is taken, the decision can be made public once arbitration is complete. There is also a civil process allowing people to sue the city regarding alleged police misconduct. Step 1 is a person sues the city. Step 2, the case is taken to court and the city attorney defends the city in the case. Step 3, the case may go to a jury who decides if the officer is liable and to what extent there are damages, if any. If the officer is found liable, the city pays the decided money damages to the person. The criminal process is for alleged police misconduct investigated as a crime. Law enforcement launches an investigation of potential criminal activity. At the end of the investigation, the prosecutor decides if there is enough evidence to charge the police officer. The prosecutor takes the case to court, where it is decided if criminal actions occurred. Section 13, Minnesota Government Data Practices Act. The public can access Department of Public Safety data through the Minnesota Government Data Practices Act. The DPS is required to make all their data accessible to the public. This includes criminal records, such as the state's offender lookup website. Data requests are made over the phone, in person, by mail or email. Documents, entire records, databases are available to the public. If DPS does not keep a record, they are not required to collect or create data for the requester. They may not always have data in the requested form, but will allow the requester to convert data themselves. There is also no charge to look at public data. There may be a charge for copies. The Department of Public Safety's website features a Class D driver's license application, as well as applications for liquor licenses and motorcycle licenses. There are links to divisions within the agency, as well as links to report unsafe driving and run criminal history checks. You can also submit motor vehicle crash reports, and complaints can be filed online. This concludes the presentation on the Department of Public Safety, an agency that covers enforcement, licensing, and services for the state of Minnesota. Thank you.